welcome back. This is SC Coleman. Today, in this video, we're going to be talking about a variety of topics which essentially revolve around our current understanding, anyway, of equitable control, or equitable supremacy, perhaps. So there's a lot of examples about what a equitable court actually is, and what we call a court of justice today is in fact a court of equity. But there's other entities which are not in modern parlance or modern verbiage, whichever word you wish to use, which are not actually called courts, but they are in fact courts of equity. One of those is a city council of the representative heads of a municipal corporation. That is a court of equity. So first, before we talk about what exactly a court of equity really is and what equitable justice means, first thing we should understand is that this is not just any court of equity in our judicial courts of equitable supremacy, but very specific to the control by bloodlines and the recognition of equitable value in blood. Essentially what you would call the inheritance by birthright having to do with blood percentage, relates to the most apparent heir of a equitable bloodline empire. So the idea of an equitable court is that in this system we have, the only recognition revolves around equity or equitable value. Another similar word would be equal value, which is the reason why the so-called courts of justice today use the scales as their symbol. The scales are a symbol for weights and measures. It is used to determine the value based off of weight compared to something else. Equal weight, equality of value. And when these courts convene, they only determine matters of equity. They don't determine matters of anything else. It's a waste of time to try and get a court of equity to make a ruling about oath breaking, for instance. That doesn't inherently have an equitable value to it, but you can term certain things under the equitable entity, such as breach of contract. Contracts have equity. A breach of contract comes into the terms of equitable value. So systems of equity, as we know them today, corporations, they're structured under the principle. And there's that repeated phrase, which is actually in fact inaccurate, which is that notice to principal is notice to agent is notice to principal. That's not true. Agents are supposed to declare and do things on behalf of the principal, but there's certain notices that you must either deliver to the principal, but in many cases notices should be directed against them, not necessarily to them. The idea of offering up a notice to someone is from the good faith standpoint that that person is open to negotiate, generally. Or you're informing them of something that they need to know about and they can decide to act on it or otherwise. If they have cut themselves off from notices, it's a waste of time to deliver a notice to an agent, which is usually how that phrase is used in context. Meaning, I'm going to waste my time delivering a notice to a belligerent opponent, letting them know that I know what they're doing is wrong. Obviously, they're going to laugh in your face. It's a waste of time. So, notice to agent is not notice to principal, and the principal is shortened to the word prince. A prince is, effectively speaking, a principal. And of course you have the term principal used in schools, but it's specifically a term in equity that has to do with the essentially liable head of an organization who is not necessarily the beneficiary, but rather a principal can be the beneficiary, but it is the main entity in control of the main singular individual in control of a corporate entity. So like you shouldn't, but today you have all kinds of weird things going on, but you shouldn't have a company as the principal for another company. It should be, so like the chief executive officer often is the principal, the one who signs the checks, essentially. Could be the chief financial officer, of course. An agent is simply carrying out things in lieu of the principal, so as the lieutenant, essentially. Now, the U.S. Code 18 U.S.C. 983 D6 defines owner as interest in property that can be forfeited, and like I said before, notice to agent is not notice to principal. The reason why that's important is because the U.S. Code Corporation is a multi-owned subsidiary, and the U.S. Code is the policy of the U.S. Corporation. That U.S. Corporation being a multi-owned subsidiary, when it establishes these equitable courts, it's doing internal court systems for regulating the commercial interests and equitable property of the corporation. Now, the reason why it's a multi-owned subsidiary and why that's important is because a wholly owned subsidiary has one single company in control of it. A multi-owned subsidiary can have the controlling interest changed based on which corporations come along and hold more, essentially, shares in that corporation. The U.S. corporation is one of those. The controlling interest can change depending on shareholder majority. And of course, a lot of these things are elevated beyond reach of regular people because essentially we are equitable property. We are owned as interest, which can be forfeited. And the best way to say that is that when somebody comes along and says the so-called government has invested in you and they're going to get a return on your investment, which of course is a phrase you hear a lot in the military, that relates to equitable interest, which can be forfeited. Of course, any interest that you have can in fact be forfeited on that essential claim that you're that there is equitable interest in you by the so-called government, which is the U.S. corporation. And all of the state corporations and all of those are just subsidiaries of the main U.S. corporation, which is a multi-owned subsidiary. So natural people are always going to be considered equity in the corporation. And everything you do have, say, or will experience in life, they have an interest in which they can then stake claim against that interest to forfeit what you have. That's essentially the same idea as being born with encumbrance. So, a juridical entity formed under the oath of the incorporator is essentially speaking the only entity that can be it's the only entity that can in fact own anything. But if you owned a company, your company can still be forfeited based off of the claim that there's interest in you, and so anything that you do, have, or say can be forfeited under claim of that interest. So when you incorporate something, you're putting it into body. Essentially, that's what the writing is. You're putting it into body. And all of these naturally have to do with a concept that's contrary to freehold. Free bottoms make free goods, that type of thing. because all the way up to the top of the pyramid, the ones who declare claim over and interest in everything do it based off of birthright or bloodline. And so if you're not of the blood, then you'll never be able to actually own anything, and everything can be forfeited for their claimed interest. So in the equity court, black robes are worn. They're also worn by magistrates and priests. However, in other courts, different colored robes will be worn. And because we only know about equitable courts, we only ever see courts of so-called justice under the guise of black robes, no other color. So there's different types of property that can have interest in it, which will be then forfeited, as is the USC Code or the US Code's ownership definition, which is essentially speaking beyond what we consider slavery. It's in many ways far worse than what we consider slavery, being forced to work for someone else and having them own all your stuff. Well, in this case, you're born encumbered and you are controlled based off. It's pretty sinister what they've done. But the different types of property include, of course, intellectual property, your creative works. And they'll obviously claim interest in anything you do. Now, this relates to the alienation of goods in the Vatican Code that I did a video on previously, where it talks about the three different types of goods and how the objective is to alienate goods on behalf of the Universal Church, leveraging all so-called civil structures to do this. And that's essentially what we're looking at today. We're looking at how all of these three types of goods, temporal, spiritual, pastoral, all of that, those are all alienated. They're encumbered. And we live alienated lives of encumbrance. And essentially that's what it means to own nothing and be happy about it, as the often quoted Klaus Schwab. So how did they do this in the United States? It's probably the same with most parts of the world, but they instituted a conflict, fraudulent or otherwise, which then allowed them the pretext to declare the United States Constitution as abandoned. And we see this done many times in real estate. We, as encumbered individuals, can never own anything under their system. And so therefore, even if we're living on real estate, they can still declare it abandoned and take possession. And that's what they did with the U.S. Constitution. Intellectual, equitable property, they took and absorbed into the possessive, into the possession, into their archive, essentially. And then they revised it to an equitable perspective to conform to the rules of equity, because they, after taking possession of the declared abandoned document, stated that they have controlling interests and therefore they can revise it to fit the rules of equity. And so today, because of these things they've done, we essentially only understand the world, culture, custom, and tradition, and concepts all in terms of equitable value. So this gets into the laws of possession. See, what they do is they hijack the laws of possession. They operate under the laws of possession, but they leverage it to acquire things against any other concepts of law and for the benefit only of the bloodline control structure that stakes their claim. And most of the people, in some ways ignorantly, who operate in these systems and are going around doing this stuff are doing it on behalf of course, those people that they'll never meet, never know about, and consider them all to be of equitable value as well. So when it comes to the law of possession, the essential idea is that the possessor of something is the owner of it. So if you don't possess it, you don't own it. Somebody else can come along and take it, and because they possess it, they now own it. That's the same idea as the ownership of silver, gold, or bearer bonds. The bearer of them is in possession of them and therefore the owner. That's essentially the idea of the laws of possession. However, they only ever recognize the legitimacy of their possession and no one else's. So that's sort of skewed in the sense of law of possession being equitably and equally administered to all. They only do it in one way because their courts of equity are essentially speaking internal to the corporations they control. So salvage is the concept that something is abandoned and you seek out the owner of it, or if there's no apparent owner, it basically becomes yours and it runs in line with the law of possession. The bare bones law of possession doesn't recognize theft, but with the idea of salvage, you can steal somebody's stuff by taking it, even though it's abandoned, and not actively trying to find out the owner. If you don't actively try to find the owner, then you can essentially have stolen it under the laws of salvage. Free bottoms are similar to the concept that in the law of possession, if you have it in your possession and you're moving it, in that sense, you're free to do what you will with the space that you have, right? They can't come and inspect it. They can't get in your business. They can't get in your nose. If you control this space, you can transport things. That is the idea of free bottoms. It relates to the bottom of a ship, the cargo hold. And that's also where you get the idea of a free hold. The cargo hold on a ship is part of the free bottoms concept, which can also relate to property of intellectual value or land. In many other cases, the freehold can be applied, but it's generally understood in the case of land. A freeholder of land holds it without encumbrance and doesn't pay anyone for the enjoyment of that, holding that property. And if they, of course, choose to abandon it and then never claim it, then it can be, of course, salvaged by someone else. But if they then come along, they can stake a claim on the property after a while. And then, there used to be anyway, ways of getting around that. But in our current system, there's no way for somebody who's encumbered to argue for possession in the current system of bloodline-only equitable courts that we have. So, in the idea of the equity court viewing the law of possession, only they can possess something, and that's only on the behalf of those who are free of encumbrance, essentially the freeholders based off that bloodline rule. The patent office is another court and bank that we don't recognize to be such. And essentially what they do is they store letters patent, which are valuable objects detailing ideas, interests, different technologies. All of the patents have equitable value. And when you go and willingly deposit your patents of equitable value, you give them another angle to stake claim on it. The first, of course, is that you're encumbered as an individual, and that anything that you own, ever do, or will have done is their property for their control and interest in you, their so-called investment. But if you deposit it with the patent office, then they have the secondary claim of the fact that they own control and interest in the patent office itself, and anything deposited into that patent bank, as it were, they have control and interest, and they have the most apparent claim to it. It's a multi-layered trick. And most of the time, those controlling parties with controlling interest are foreign, which is the reason why people come along saying things like the Chinese government took over the patent office. No, they really didn't. They just might at this time have controlling interest in the U.S. Patent Office, but that can change, and they're also a multi-owned subsidiary with foreign controlling interest, and so it's multi-tiered layers so that the people who have encumbrances placed on their life won't be able to find out who ultimately did it, which would of course be those bloodline controllers. So now we're going to get a little bit into concepts outside of the equity, and to understand that the equitable institution, not only was it placed as supreme over everything else, so maritime law, admiralty law, martial law, all laws were essentially speaking placed under the umbrella of equitable control. Well, there used to be something called lawfare, which today it's like everything else been forced into to conform to the rules of equity. But it used to be that equitable courts were a component of lawfare, not above it. They were a singular, separate court entity from other courts of law. And that's what lawfare is. It's just like you go to the fair and you have different vendors. Well, lawfare is different places to go to administer different things with law, right? If you had a issue with someone violating their oath, you would not go to the court of equity. You would instead go to a specific court that administered oaths. Or with heraldry, patents of nobility, that didn't have to do with an equity court value decision. That had to do with usurpation of the rules of heraldry. So that's what lawfare is. Today, it can be seen in some context where you have internal affairs and boards of review, and those, essentially speaking, are courts that don't entirely have to do with equity. They're courts of conduct. And in many cases, they're a component of a mostly equitable perspective towards lawfare. Law, of course, and the concept of what we understand currently as law, which has been distorted beyond all previous recognition, well, it's all based out of tradition, custom, and practice. Now, the first one, tradition, is the foundational concept, the foundational structure. It is something that is ingrained into a culture for a long time. Tradition is something that your fathers and your forefathers and their forefathers and your ancestors did. That's tradition. Custom, on the other hand, is something that can be changed, but is generally a pattern which is shared by a group, right? You get a group of people and they all do the same, similar things anyway. That's a custom. It can easily be changed. It's easier to change than tradition anyway. And then practice is simply the general activity of doing something. The understanding and knowledge that revolves around a practical matter, such as a so-called law practice or a medical practice or any of the other types of practices. Martial arts is a discipline and practice. You have, of course, practitioner. Those words have been distorted to mean something about equitable title, but they, in the past anyway, had a different connotation to them. And they, in many cases, had a different definition that we don't use anymore. So all of these are changed to conform to the rules of equity, and that's the reason why you find people going around and changing their appearance, not engaging in certain activities, recognizing such a thing as cultural appropriation, especially when it comes to so-called Indian ceremonies. That's because they're placing equitable value and value control on these traditions, customs, and practices, so they can then acquire them as essentially possession and intellectual property of their corporation. So whenever you go to an equitable court, you have to understand that they can only make determinations on matters of equity, not oath-breaking or other examples like I said. So if you attempt to represent violations outside of the realm of equity, generally they'll say things like it's irrelevant and they can't decide on it. So if you're going to try and play the game in the courts of equity that we have today, which only recognize the volition and right of ownership as others, and that if you're a U.S. citizen, and in many cases there's codes across the planet that all conform to the same concept, well, then you are incapable of ownership. The definition of ownership is that which you can forfeit anything with interest. So punishments will only ever be equitable. There will be no punishments for treason. You can't, it's a complete waste of time to try to present charges of constitutional violations in a court of equity, because the Constitution is simply seen as intellectual property of that corporation and bears no relevance in the equitable proceedings. You have to do things according to the rules of the equitable court, however they've laid those down, usually against the interest of those who have been deemed incapable of ownership, according to this U.S. Code definition. So that is a strong explanation and understanding and a way to rationalize why you have so many attorneys, judges, bailiffs, sheriffs, and various other what appear to be human beings who go out of their way to defend child traffickers. It's because in their mind, in the equitable system, child trafficking has equitable value, and thus the relevance of the court is to protect the equitable value that they bring, as essentially the interest in their business is held by the so-called government. So when you understand what you're dealing with, you start naturally, somebody would look outward to try and find other courts, because once you fully realize the situation, you know you'll never get anywhere in a court of equity that doesn't recognize you as being capable of ownership and living an encumbered life since birth. One of those other courts is a caricature, I believe, a caricature to denigrate other types of courts beyond the courts of equity by minions who are propagandists and interdispersed in communities to characterize and then insult and mock the outcome of real concepts by putting them into a certain, marginalizing them, right? Well, the first one is La Commissione della Cosa Nostra, or often called the Commission or the Murder Commission. La Cosa Nostra means our thing. It's Italian, and it relates to the so-called New York Mafia of the 1930s and Prohibition era. So basically what this court did was they decided on matters of death. It was a commission formed up of the various heads of, or mob bosses, the heads of different organizations in New York. And somebody could bring against, or up to, for consideration by the commission, claims of actions or offenses against the organization and against the commission itself. And then they would decide what the recourse would be, whether or not they would put out a hit on the one individual who was implicated, or individual. However, we have a strange situation today where you have judges of these equitable courts who are making rulings outside of relevance, partially because they don't comprehend the fact that they're bound to the court of equity to engage only in matters of equity, but instead they consider themselves essentially as sovereigns alone, sovereign themselves, and they make rulings and decisions which are far outside of the relevance of their equitable court, essentially going rogue, going off and doing whatever they want. So that's important to understand what you're dealing with. If you ever run afoul of these equitable courts, you should look at it and say, is this judge an adherent of the rules of equity, or are they going to make rulings outside of the relevance of equity? And depending on what you're dealing with, would dictate how you are going to approach this. If they make rulings outside the rules of equity, then you understand that that person can be pushed to do things not in their purview. On the other hand, somebody who will adhere strictly and only to the rules of equity, then you should be able to present something based out of the rules of equity and essentially play mind games with them. And we'll get into how to do that in a little bit. Now, if you're going to deal with these people, you have to act and engage with them, all the parties involved, right? The sheriff, the bailiff, the bondsmen, the bounty hunters, the judges, and the attorneys. You have to engage with each and every one of them organizationally outside of the court of equity. You do not play their games. You don't play their rules. And essentially, you tell them personally at their house, their office, wherever they are, you do it outside of that scope of the equitable rules. You stipulate you will not recognize their fraudulent rules, their fraudulent authority and control imposed under rules of equity, and that if they continue to proceed as members in this equitable organization, then they will be subjected to letters patent, putting up a bounty for their heads. And if you're going to do this under the Constitution, then you'll have to pay it out in gold and silver, because the U.S. Constitution directs that that's the only way to absolve a debt or to discharge a debt. Now, this idea of putting out a letter patent for a bounty, not only was it ubiquitous in the so-called Wild West and not done solely at the discretion of sheriffs, which didn't exist at the time, but it's an absolutely constitutional mechanism to deal with these entities. And the main thing to understand when you're talking about these courts of equity is that they put themselves up as belligerents when they claimed that the U.S. Constitution was abandoned and that they were going to take possession of it, and essentially then they passed the Stamp Acts of 1863 stating that all things were repealed and all this other stuff. They committed a fraud, and then they put uniformed armed soldiers that we call law enforcement against the people as belligerents in warfare. If they take possession of you, they are in fact taking a possession of a prisoner of war. That's what you are when they take possession of you. That's because they decided to engage force of arms. When they did that, they became a belligerent, a hostile enemy belligerent. And you have to deal with each individual outside of their court structure personally as enemy combatants. Now, when they if you were going to set up a court to decide these things, you wouldn't do it in their courts, right? Many courthouses, they have metal detectors and they have a prohibition on firearms and weapons. That's because you're going into enemy territory every time you enter. They are hostile and belligerent to you because you are, according to them, property, which any interest you have can be forfeited. And so therefore, that is done through force of arms. So you have to understand that anytime you dawdle around and say, oh, I don't want to get involved or anything like that, they already instituted a hostile environment and they already set themselves up fully aware as belligerents of the people they were claiming ownership over. So if you want to make claims against these courts of equity, and if you want to do it right, you cannot do it in their system. You do not go as an emissary into the courtroom and state a bunch of nonsense that all the sovereign citizen American national crap kept suggesting you do, because you are in their control. They have possession of you. It's going to go exactly as you expected. They're going to treat you as a piece of property. You have to do it and deal with personally each and every individual. Forget about the so-called threats against judges and all the nasty things you'll do to them for threatening judges. You, essentially speaking, deliver in a professional, legal, structured manner declarations against every person involved at their home addresses. You find out who they are, and if there's no real people involved, well, then you find out who you can hold liable, who can be held to account. Naturally, when you're forming courts, if you want to form courts that aren't equitable, then you'll have to find a location, and you'll also have to decide matters, form actions, and conduct proceedings according to different rules. Because if you follow the rules of equity, then all you're doing is making another court of equity. That's it. So I'll just state it again. Claims against equity courts should be formed against the individuals involved, not inside the court office, because it has set itself up as a belligerent by making claim against possession under force of arms. It can't be reiterated enough. If you're going to make claim and you're going to stand your ground against these people, you simply cannot do it in their offices. It's a practical matter because they have force of arms in those offices, and if you're going to do it, you have to bring force of arms. You have to come from a position of strength. Everybody knows that in any negotiation, you do not negotiate from a position of weakness. As the saying always goes, you're not in a position to negotiate. That's what the response always is in movies, TV shows, whatever. It does prevail. Now, military courts are another type of court that's outside of equity. But there's, in the military, and especially the Marine Corps, there's types of courts that are not called courts, but essentially speaking are. The first of those is the idea of requesting mast as the main mast on a ship. It is a convening of a captain's court to decide a particular matter. Now, in the Marine Corps specifically, and although it is terminology that comes from a Navy, the captain of a ship in the Navy is usually not going to be a Marine. It's usually going to be naval. But Marines have the right, all Marines, regardless of rank, position, status, bloodline, birth, whatever, it doesn't matter, all have the right to request mast. Now, obstruction of the requesting of mast, which you won't find this on Google or any of the other nonsense, but anybody who's been in the Marine Corps, they will have heard about senior enlisted staff NCOs and other officers denying requests for mast to the commanding officer of a unit. When that is discovered, generally the person who denied the request is going to get in a lot of trouble, not because they denied the request of a frivolous action, but because that's an offense against the commander's authority or the commander's discretion. Because when they make that determination that something is not worthy of the commander's view, then they are making decisions for the commander, and that's pretty bad. That's just like when somebody in any corporation decides they're going to speak for the manager. I don't know many managers that would take that to be a small deal, something that's insignificant. Most would take that as a personal slight against them by the subordinate. So the next one are called courts martial. Courts martial are really misunderstood today because they're only ever framed in the term of the equitable ruling structure of the Uniform Code of Military Justice and the military tribunals of specific officers, the judge, advocate general, and all that stuff. But the word courts martial are actually courts of force, and there's many types of courts martial. In many cases, the courts of equity that we have today incorporate courts martial because they are formed out of the use of force. They use chains, they use beatings, and they use the gun. Those are all terms of force that makes them, in fact, courts martial. Marshaled, under arms, and they're holding court by force. That's what a court martial is. So anytime somebody comes along saying, when is the United States or other countries have been put under court martial or have been put under martial law, they don't usually know what they're talking about, because in most contexts, every part of the globe has been under martial law for a long time, because it's might makes right. Whoever's got the most force wins, and you adhere to threat. And we've all been living under that this entire time. When you get pulled over and given a citation by a law enforcement person, so-called, you comply with them simply out of the threat of them using a taser or a gun. That's under duress, and that's martial law. Interestingly enough, the so-called commission was, in fact, a court of martial force, right? It was a court of death. They chose when to kill somebody, and the fear of them putting out a hit was what mostly kept people in line. That essentially is a court martial, a court of force. So it doesn't specifically only apply to military. Technically speaking, they say that law enforcement's paramilitary, not true military, but they in fact are. They're occupation forces, forcing people to do things by their uniform and under arms. But those are some different types of courts. The reason why the military courts specifically are not courts of equity is because they don't always decide things that have to do with equitable value, like the current judicial system that we have today. They will decide things like conduct unbecoming. That has nothing to do with equity, that has to do with conduct. But they can decide so many different things about treason, of cowardice in the face of the enemy, of drug trafficking. You can have all these different charges, and they have a way of administering them that does not conform to the rules of equity. And that's what makes them a different type of court. So there's a movie called Bounty, about the ship Bounty, which I believe to be a fictional account, which is listed as quote-unquote historical. But either way, there's a trial in it, the trial of William Bligh, which shows court proceedings in the context of the Admiralty Court and doesn't appear to have so much to do with equity, except it seems that a lot of the trial in that movie reflects the rules and procedures used in a court of equity. So it's very difficult today to find any sort of materials, books, what have you, to comprehend, understand, or learn about courts that are not of an equitable nature. And in fact, about the only way that you can find that today would be in a military outfit. Otherwise, you'll never have any experience or understanding about these other courts, unless, of course, you recognize a board of conduct review to, in fact, be a court, among other things. Google, interestingly, is a court of information. They form actions against information, but they do it under the claim of equitable interest for all that is published on the platform. Anything you publish or anything that comes up on Google is, essentially speaking, their intellectual property. That's an interesting claim, considering Google is just an internet search engine. It runs scrolling software, and just that simple mechanism alone, and because they have the backing of the judicial equitable structure today, they stake claim on anything that comes across the Google platform. So, as far as the equitable supremacy, the propaganda that relates to conforming everything to the rules of equity, and particularly the fact that they have equitable control over everything, we only understand bounties in terms of how they do it and not how it was done. There is still somewhat of a carryover in the embedded cultures of the Americas about how it was done in the so-called Wild West. where you might have a community come along and post bounties. And of course, in the Middle Ages, you had different bounties that might be posted on village bulletin boards and things like that. So in order to post a bounty, the first thing you need is to post the reason, to say why, so that somebody can look at it and say, is this a just cause, right? Does this person warrant whatever the bounty is requesting? And then the second one would be conditions that need to be met for the bounty to be completed and for payment to be given. Of course, then that means you have to stipulate the type of payment and how much, the quantity. And then, of course, the next thing you would need is the name of the person who the bounty is being put on and associated information to help the hunter in targeting them. Most of the time in this context, you would want hunters that are able-bodied and knowledgeable, capable people. This is a mechanism that allows those otherwise inhibited to enlist the help of others that might protect them and help them out, others that are capable. Obviously, an old person who's severely disabled is not going to go hunt down the target of a heinous crime that was done to them, and which will not essentially be have justice served in the courts of equity. And so they post a bounty allowing somebody else to go after them, especially if you have... Nowadays, you have so many cases of elder abuse that simply go ignored and are buried, and that's because there's no mechanism to administer against the offenders. The courts of equity protect them because those people are simply doing their equitable part for the corporate interests. And so therefore, something like this would be important. Now, you should also understand, of course, that as soon as people start posting legitimate bounties, there will be a flood of fake ones to dissuade people, to dissuade true bounty hunters that are not only associated with the courts of equity from doing their purposes. Because there's a lot of propagandists embedded and who are working with, fully knowledgeably, in tandem with these equitable bloodline supremacy structures. The military and many other outfits post closed bounties, and basically what that means is, contrary to what I'm talking about, which is an open bounty, the closed bounties are only offered to certain individuals. And so the military, many of the military structures, might post a closed bounty and offering to the various security corporations and different private sector military outfits. And then those people will determine whether or not they want to follow up on collect on the bounty. That's how a closed bounty works. In many cases, closed bounties could absolutely be done in communities, but in most cases, the communities are so divided, so in distrusting of their neighbors, and not at all. It's because the customs, the practices and traditions have all been usurped and conformed to the rules of equity, that the equitable controllers do not want those people to be actually sociable together, so that they can't do things like form closed bounties and administer community courts of justice outside of the equitable ones. That's a very important thing to understand there. Understanding leads to appropriate response. When you understand what you're dealing with, you can accurately surmise what's going on and formulate a response that's applicable to the situation you're dealing with. And so that's what we're going to talk about here. Apart from obviously everything else I just covered, we'll talk about relevancy in matter. So, in many cases, when you're talking about martial law, of which these equitable courts are acting under, to be honest, they're acting under the laws of war. Now, those are not the articles of war. There are many different laws of war. There's different ones that have been stipulated and regulated. But generally speaking, the only rule in martial law and the laws of war are effective measures and use of force. And, of course, negotiating. So that's where we get into the idea of relevancy. There's essentially 4 key points that should be asked when you're determining relevancy. One is relevancy of evidence. Is the evidence relevant to what you're doing? If it's not, then the irrelevant evidence may need to be used in evidence in a different context somewhere else. An example of this is that the military courts determine that violation of the rules of equity do not concern them. Petty theft, in many cases drug trafficking, unless it's a member in the armed forces itself, but regular people going around drug trafficking, stealing things that aren't property of the government, of the military, doing things that are considered violations against the courts of equity are not going to be administered by the military. So that would, of course, if you present them evidence, you have to present them evidence in a way that it's relevant to what they do. So if you send a report to, say, the the Reserve Command at Fort Liberty, you should term it in ways and show the evidence that damages things like domestic tranquility and may lead to widespread conflict. That would absolutely be in the purview of the military. The relevant case is the next one, and just like in our example, if you take a situation about a personal slight to you, well, most military outfits would say that's not relevant. If you take a situation of a municipal corporation, so-called government, going around and harassing and antagonizing the population, inciting them to rise up, well, unfortunately, in most cases, the actual rising up of it wouldn't be a bad thing, and if you reported that to the military, in the past anyway, the military might have actually suppressed it in favor of equitable control of the municipal councils. The idea would be that you would term it in the way saying that if they leave the equitable councils in their position, those people inevitably, because of their hubris, arrogance, and hostile, belligerent activity, will incite the populace to rebel, to attack them, to hang them, kill them, and that removing the people who would in a community that would possibly do that will not remove the cause, which is the city council. And in many cases, the county commission and all these different groups, they work in tandem, they're all friends, they all work together, and they all incite the population through belligerent, arrogant activities because they only see others as their possessions. So the next one, of course, is relevant cause. You'll find this often where somebody will ask you what you wish to gain out of it, what you wish to be the remedy. Courts of equity often ask this, and they do this in the universities too, as they say, well, what would you want out of it? That relates to relevant cause. If you want something to get fixed and changed, you have to term it in ways that it is associative to the relevant, where you're taking it to. You know, if you want the military to go in and find someone and then hand you what they find it, they're not going to do that. If you want them to go in and remove enemy agents, combatants, and perpetrators of pretty heinous, treasonous activities, yeah, they'll do that, right? But if you request some sort of personal gain, they probably won't help you out there. So those are, they might, if they're going to do what their purpose is, that's one of their purposes, allegedly. But again, the military we're dealing with is still a component of this equitable structure. So I wouldn't expect them to do anything else against these courts of equity because they're part of the system itself. So relevant standing is the last one, and that comes down to, are you a party with standing? And there's just so many different ways that can be construed depending on who it is. Obviously, in courts martial of the military, as most of us understand it, only uniformed members of the military forces have standing. Otherwise, nobody else is standing in those certain situations. Interestingly enough, in the equitable courts that we have today, the only individuals who have standing are either agents acting on behalf of corporations and with some sort of interest, or the bloodline, control structures, or corporate agents of the equitable court system itself. Those are the only ones that have standing to even argue anything, to even talk, to do anything there. And in many cases, a lot of communities might have a rule that the only ones who can have standing are those of the community. So if you want something to be done in that community, you actually have to go to somebody in the community and have them present it towards the community court. And the same with La Commissione della Cosa Nostra, or the commission. The only ones that would have standing would be members in the organization of La Cosa Nostra. Likely, anyway. I'm not entirely sure, because that is most cases a fictional characterization in order to denigrate the idea of courts outside of the equitable structure. So the next thing, when we're talking about how to engage in this these concepts, and to conduct oneself in a professional and competent manner, well, the first thing that you want to do is you want to sidestep the terminology control that was imposed by the rules of equity, of equitable bloodline supremacy, and applied to various concepts. So you employ the concept, but under a different name. So if you're going to post a bounty on somebody, you don't call it that. Call it something else. If you're going to form a court of conduct, you don't call it a court of conduct. You call it something else, which is exactly what corporations do, and exactly what many other entities do. They simply put in place the concept by another name. Now, the next thing you can do is you can apply that to standing as well. Instead of going to the equitable courts today under an already encumbered name, you simply use a different name. Now, obviously, it takes some work and understanding to establish that different name. An example of this would be a pseudonym, an author name, where you write works and then you stipulate that that name applies to an entity, a creation, alone and separate from the creator, thus taking away their ability to stake claim of encumbrance on your so-called legal birth certificate name. And then you state that instead you're operating under this name. Now, a lot of Indian nations did that in the past, where when you got adopted into the Indian nation, they would provide you a different name. You were free from encumbrance, and you were recognized as free from encumbrance by that Indian nation. So if somebody came along stating they had claim against so-and-so, they would basically look at you and say, that person doesn't exist here, because they don't recognize the name. That's a big deal. You can obviously form this further by making an association of unencumbered names, right? You create the name separate, and they do this all the time. The example of this is the Vatican Bank, which is a so-called separate creature of the sovereign, the Pope, with a different personality and a different purpose, which is separate from the Vatican itself, essentially, and essentially can do its own things, and therefore you can't hold one or the other accountable together because they're separate. You would have to get them on, like, conspiracy, which is a really weird thing to think about in that context. But either way, that's how you create an unencumbered name. Don't fool around with the encumbered name, other than to say that they fraudulently did all this stuff and nonsense and all that. But if you want to play their game in the courts of equity and drive them crazy, well, that's a way to do it. And then if you form association of encumbered names, that extrapolates it further. And basically what you're trying to do in that context is provide a response to the charge of encumbrance. They don't usually say that. They come along and say things like, you have to adhere to this and all that stuff, and then you come along with a response, well, that's not my name, I'm so-and-so, and you have no claim against me. Often it's reduced down to force of arms, though, in the contest, which simply, usually out of brainwashing, most people don't want to step over that threshold. So like I said before, the equity courts have to do with equitable value. They're essentially speaking a bank. A little bit different than what most of us understand to be a bank, but they really are. Officers of these equitable courts draw up bills of charge, just like you would have at any restaurant. The bills of charge must be paid, or the customer will have to post bail. They have to leave something with those rendering the bill of charge before they're allowed to leave. If you go into a restaurant and you can't pay, then they ask you maybe to leave something for them to hold on to, like your license or your ID or whatever, until you come back and pay the bill of charge. That's exactly how these courts work. That is where you get the idea of a monetary bond being held until charges are paid up. These charges, we have been distorted to understand they're actually essentially the same charges you would get at a cafe or a restaurant. You are a customer as part of their monetary equitable system of fraud and trickery. And this is where you get the phrase, the debt to society. You have to pay the debt to society. They know what they're talking about. Now, when they issue a warrant, it's for the possession and reclamation of court property. You are property of the court until your charges are paid up. And that's how their system works. It's very simple. You have to know what you're dealing with in order to appropriately address it. So procedures, of course, will be inherently different among different courts, and if you're going to make a court of claim against these courts of equity, then you'll have to follow different procedures than they do. And also make sure that it's outside of the questions of equity. Or if you're going to form a rival court out of equity, that would be pretty weird. Most attorneys are familiar, even just in practice and understanding, with how the equity courts work. They just don't render that perspective inside of their brainwashed and manipulated, programmed concepts and activities. So, Social Security numbers are essentially access codes for a joint account with the terms administered by the fund managers. So if you think about this, what they always say is Social Security you pay into of your life so that when you're older, you can then take that money out. So you are paying into a bank, and then that fund that's paid into the bank, that joint account held by you and everybody else that holds Social Security numbers, well, the terms of that account are stipulated by the administrators. You have to stay in line, you have to follow the terms and conditions of that fund, or it will be revoked. Your access to the joint fund will be revoked. That's essentially what they did there. Our current social order is specifically tailored to the rules of equity in all senses, rather than the rules of equity being tailored to the social order. That's the big thing. In the past, courts of equity, whatever you want to call them, there's a bunch of misinformation out there about courts of equity and where they came from. Either way, in the past, these specific courts of equity where people would go to relate and to bring up matters of relevance to the court of equity, those would be tailored and fitted to the culture, the custom, traditions, and practice, to the social order of that place. And right now, it's the other way around. The social order is tailored to the rules of equity. So, when you look at the U.S. Constitution and how it stipulates that Congress is responsible for establishing post roads. We understand that when they claimed abandoned the Constitution, took possession of it, they also staked their claim on the post roads and highways and land developments and every single thing they claimed controlling interest over, and thus took possession of it in that concept. So when they form a jury in their offices of equity, that jury is not actually a constitutional jury, because the Constitution has been subsumed under an umbrella of equity, as they would see it. Instead, those juries are separate to the rules and regulations of that equitable system, and they're only there to determine on matters of equity as well. When you swear in the members of a jury, the French word to swear, jurer, those members of that jury are there to swear to essentially follow the rules of the equitable court. And so neither will they administer matters of relevance to anything else like oath breaking. So in order to comprehend all of this stuff, it would be good to briefly look at the history of law. It starts with the longhouse, the Scandinavian concept, which is also carried over in with Indian cultures and in Asia and pretty much everywhere. In the longhouse and in taverns, which are essentially the longhouses of sailors and shipmen when they travel around, the role of alcohol is absolutely paramount. And in order to give a different perspective towards this, I'll read from the book, The Levantine Adventurer. Bear with me here for a second. This is the Travels and Missions of the Chevalier d'Arvoux, 1653 to 1697, which I've referenced many times, by Warren H. Lewis. This is a first American edition from 1963 with the original 1962. And now here on page 16 it states, having landed in the hot glare of the consular wharf, he was at once plunged into that ritual of ceremony which was to regulate his life for the next 25 years. First there was the consul to be visited, then after a brief exchange of compliments, that official provided him with a guide to take him to the home of his Bertandi cousins, where he was to live. They received me with perfect kindness, he wrote gratefully, sent for my luggage, and gave me a room suited to the plan which I had formed to study business and Oriental languages. Then there was in his letters of introduction to be presented. So here we start. He first presents letters of introduction, after which his relatives carried him off to make his duty call on the Qadi or judge, the senior resident Turkish official with whom he had long conversation, finally broken off by the Qadi's order to a slave to perfume the visitors. A censer burning incense was waved in Darvoux's face, and his cousins whispered to him that this was the signal for them to make their adieu, which means to leave. Say goodbye. And this seems to have concluded the tasks for his first day ashore. One can imagine something of his sensations when he was at last got to bed after that unforgettable and unrepeatable experience, the first day in the East. A confused jumble of impressions, stalls heaped with unknown fruits and fish, a laden camel, pretty girls with provocative alien glances, loathsomely deformed cripples, a buffalo cart, the shrill meaningless babble of dense crowds which talked unceasingly, and over the tyranny of a sun which pressed down on the shoulders like the hands of a giant. Like most Oriental towns, Smyrna proved somewhat disillusioning on closer inspection. Behind the imposing buildings on the waterfront and their background of mosques and khans lay the native town, a place of cramped single-story houses built mainly of mud and wattle. To construct his house, each dweller had excavated a deep pit, which thereafter served as a cesspool, and which filled with water. And all of this stuff is sort of inconsequential to begin with. But now, on page 36, we will look a little bit at the role of alcohol in the preemptive visitations that will follow or lead into the establishing of a court. Essentially, you have to go around and know your neighbors before you can form a court or bring up matters of importance. This has been part of human nature and custom, tradition, and practice for a long time, and in many cases it still is. It's simply been removed from the hands of regular communities and put solely into the courts of equity, where they go to the Inns of Court and then they learn out everyone in that community and they administer things over everyone else. So here on page 36, it states that the Aga, much comforted, thanked Darvu and promised to follow the Muftis. That's from one visitation. In 1679 at Aleppo, Darvu had some friends made the mistake of calling on the Mutsalem, or lieutenant governor, after supper. And though they protested that they had just risen from the table, the Turk insisted in their sitting down to a second meal, and this consisted of 50 plates of roast meat, stews, fruit, and pastry. It must have been something of an ordeal. Furthermore, wine and brandy were served at a rate which would have sunk the most hardened topper, had it not been for the fortunate circumstance that in Turkey you may sit with a full cup in your hand for as long as you please without impoliteness. The supper did not end until after midnight, when Darvu left loaded with presents, including a beard comb made of fish's teeth. At first sight, it seems a useless gift to a Frenchman of those days, but we must remember that he would have been wearing a beard, as did all foreigners in the Levant. What we should have found trying in these social contacts would have been the Oriental indifference to time. A few days after the Mutsalem's party, Darvu supped with another Turk, a learned man who was the head sheriff of Aleppo. The dinner was long, the conversation longer, and fell words were not exchanged until after midnight. The host conducted his guests to the door, then suddenly announced that he must show Darvu his new buildings, the inspection of which must have taken some 2 hours, and even then Darvu had excused himself from examining the library. By 1710, Frenchmen and Turks were on such terms in Constantinople that 2 Turks, encountering a party of French sightseers, asked them into their house as a matter of course, to which politeness the French responded by inviting the Turks to dinner. On hearing of this, the French ambassador sent his countrymen a selection of his best wines to uphold the honor of the nation. After the meal, the Turks asked to see over the French flagship, and there they were entertained with a good drinking and a salvo of cannon. This, of course, is very different compared to the way things are conducted today. Only components of the courts of equity do things like this. Everyone else is too suspicious and too reserved to do things like this with their neighbors. And so that gives you an understanding of not only that the role that alcohol played, but why today it is so heavily regulated, and why custom, tradition, and practice are also equally so heavily regulated to ensure that regular people don't socialize in such practices, doing such things that might upset the equitable order. So the next thing, and of course, like I said before, external and internal courts, you have the ones externally focused and the ones focused internally on things going on in the organizations. Tea ceremonies are an example of the way that visitation leading into the presentation of courts functioned in so-called feudal Japan. Another thing that you'll never learn in the equitable school systems designed to turn you into an asset for the equitable structure are the acts of trade. The acts of trade were the main source of conflict for the War of Independence in the Americas. But even then, under the acts of trade, there were separate courts for separate fields. And many talk about how you would want a government or a court of jure rather than a de facto court. You hear this a lot with the so-called sovereign citizen characters in American National, mostly con artists who are working on behalf of the equitable system. See, the thing is, if you have no jure, you have no oath. So nobody can be bound to conduct. And if it's not in fact, then it practically doesn't exist. So you actually want both, de facto and de jure. The Lord Proprietor is another system. Lord Proprietorships was essentially sold interest that happened during the colonial period, along with the acts of trade. The Lord Proprietor as well as the acts of trade, caused a great deal of confusion, especially when you had colonial courts and you had the courts of admiralty and then you had the board of trade. You had so many different entities all working against each other in many cases that it caused a lot of confusion, and nobody who knew who was in charge of what, and then people always felt like their toes were getting stepped on, and that was very helpful for the colonists. Now today, with the universal overall rule of equity, it's a lot more difficult to do that. In England, they had ship registration, where it was required that anyone that did business shipwise had to register their vessel in England. And this creates the false image of the maritime empire of Great Britain. Majority of ships simply forge paperwork to get around these requirements, but it presents the appearance that all ships at the time period were British, which they weren't. The Duke of Orange is a listed scheme in the Levantine Adventurer book, which relates to this idea, which we can find today in the Delaware filings of the state of Delaware, where all business filings just about are run through. Physical location is not necessary. It is simply the idea of acting under a mark, license, or letters patent, which are purchased with purchased interest in an office and assurance through financial bond. And that's where you get the idea of my word is my bond as an oath. Of course, when you're talking about the fraudulent way of hiding this stuff and funneling it through, we find in the state of Delaware business filings the same thing as the Great British requirement that all ships get registered through Britain. Essentially, in the future, if we have the same historians that we have now in the future, they will all claim that at this time there was a global empire of the state of Delaware. That would be a really weird claim for us today, but that's essentially what they do with the so-called British Empire. So in the Levantine Adventure, the Duke of Orange is, page 222. So we talk about on page 221, actually, an English pirate with the improbable name of Plumin, operating out of the Tuscan port of Leghorn, had between 1694 and 1697 captured several French ships, and ultimately had become such a nuisance that Louis XIV, on the petition of the Marseille ship owners, ordered his envoy at Florence to obtain satisfaction which the Grand Duke of Tuscany, Cosimo de' Medici, would gladly have given for several reasons. Firstly, because he had the misfortune to marry first cousin of Louis XIV, and secondly, as an ally of France, but chiefly because Plumin, though an Englishman by birth, had become a neutralized Tuscan and was acting in impudent defiance of the Grand Duke's authority. For he had been given leave to fit out his corsair in Tuscan port, only on strict understanding that he did not molest French shipping. Dupré, French envoy to Tuscany, had done his best with the business, but when it became obvious that he was out of his depth, Darvaux, of whose skill all were persuaded, was asked to go out to Florence to clear the matter up. He accepted the assignment, and his instructions were given him on June 13, 1697. Darvaux was only a day or two in Leghorn before he found out the reason for the apparent impotence of the Grand Duke, which was that Plumin was skilled in legal chicane as he was in piracy. He had entered 2 pleas in bar of judgment. The particular point at issue was the seizure of 2 French merchantmen in 1696, whilst England and France were at war. Plumin claimed that he was then an Englishman, acting as an English privateer, to which the Grand Ducal lawyers retorted that, on the contrary, he was a Tuscan acting as an Italian pirate. Whereupon Plumin fell back on a second line of defense, namely that whilst he admitted his presence on board the ship in question, the King Charles, at the material time he maintained that the ship belonged not to him but to a certain Pickering, who was acting under letters of marque issued by the Prince of Orange. Though it was notorious in shipping circles that Pickering was a man of straw, and that from whatever source the venture was financed, it was most certainly not with Pickering's money. And there you have it. Same scheme repeated today in the Delaware business filings, essentially. So the other thing to understand is that trials are required for the discovery and determination. If no discovery and no determination is required, then a trial does not need to be held. It begins first with the matter at hand. On its face, the prima facie, as the idiots in the Equitable court like to say in Latin. And sentencing relates to a sentence, which is spoken or a written line, used in a particularly serious and grave manner today, but it has a very simple meaning to it. Now, arrest is French for to stop, arrêter. Trespass means very pass in French. It's an action in court of equity where interest is moved against. Essentially speaking, if we do anything outside the rules of equity, we are all passing against the claimed interest of our so-called overlords. Now, a carried pass or passport is issued by the one with controlling interest. A free act and deed is something done versus a legitimacy of claim, and it used to be that corporations, with articles of incorporation, stated this was the free act and deed in the early 1900s. That's since been removed. Now, what's interesting is the ability to have interest on other person's right and to claim on their creation, and a business being forfeited by claim of interest on the party forming the business. The federal government's so-called investment in the people formats their claim against interest for all things of equitable value done by those under the controlled interest of the so-called U.S. government, federal government, what have you. Now, there's many different types of acts or deeds. The written is considered a letter or legal instrument. The act of arresting is to stop someone, and the killing is a ultimate form of arrest, stopping them permanently. So arresting is different today. It's misconstrued to actually mean the claiming and taking of possession by an officer or agent making a claim and taking possession of someone where there is never a question of legitimate cause or contest most of the time. Usually when these people come and they make a claim, I have a warrant for your arrest, they say. They're making their claim, and now they're going to take possession and enforce it. If you contest it, it generally today will come down to force of arms. That might have changed a little bit in the previous years, but when they come, if you're going to contest it, you have to be ready to resort to force of arms. Most of the time, these people are ignorant. They're minions. They don't understand or comprehend what they're doing, and they will laugh at you, and then they will get vindictive, hateful, and violent. They are hostile enemy belligerents. When they do this, you have to be ready to resort to use of force and arms to break their bones, to damage their body, to ensure, and to ultimately, in some cases, kill them. That's the only way to arrest the unlawful action they are taking. That, of course, has to do with whether or not you're going to contest it. Because of the way these people are, generally, verbal contesting does not work. Then you get to the question of murder, and because of the rules of equity being posed on everything, it's very difficult to comprehend what exactly the word murder really means. And if you're talking about using administering a court outside the courts of equity, you'll have to possibly define the terms and how the court sees them versus the way the equity court would look at murder, which is a trespass against possessed property. Then you'll have to, of course, decide what type of court you're in or forming, where the place is to hold that court, associated definitions, a relation to type of courts, to if you need a different court for something else. Now, guilds are a type of professional court that used to exist. They would decide matters in terms of the profession of the guild. You would not take things outside of the profession or the business of the guild because it wouldn't be of relevance. what's interesting about this is that a lot of this stuff today is becoming not only more and more open, but in general has been. So when these individuals, who are pretty blatant what they're doing, want to hide something, you have to imagine that that's something really bad for them to want to hide it. So here we get into some examples. Now, the first thing to understand is that what's going on today is a building out for war. First thing you need to have is a reserve of resources, and that's something happening today. The occupation force of equity is extracting resources from those they consider their possession, right? You hear this terms of the United States and its possessions. These municipal councils, these county commissions, these state boards, the Board of Education, the Board of Developmental Disabilities, all of these are equitable courts that are extracting resources from their so-called possessions in order to build up for war. The next thing you need are manpower or an army. And they do this in terms of mens rea, state of mind. Somebody cannot be of the state of mind to their activities if they're on drugs or disabled mentally. So they can murder without the state of mind charge. That's in their courts of equity, mind you. The U.S. Constitution does not have an element for that in it, and other courts might not have that either. Now, the next portion of this video is going to cover activities that relate to this building up for war. And essentially the the threshold after the building up is what some might call kinetic activity. In warfare, you have the idea of friction. Friction does not always have to do with physical kinetic contact, but that's when you're talking about shootouts, physical fighting, that stuff. Butler County Board of Developmental Disabilities in Ohio speaks about matters required to be kept confidential in executive sessions. Now, the Department of Developmental Disabilities is DoDD, like Department of Defense, so-called. Now, the Clark County Board of Developmental Disabilities, the September 30th, 2023 meeting minutes lists the financial laundering charges that relate to this building up of resources for war. Out of a total of $1,179,905.81, expenditures are listed as the general fund of $824,464.88, community residential fund $73,477.83, FF Mueller, whichever you want to say, $274,092 and .16, capital improvement fund $7,870.94. Ohio Valley AV Buckeye Room AV system was paid $47,072.25. Now, obviously, most of those expenditures are to funds, which most of us would not consider to be actual expenditures, but they audit themselves, so it doesn't really matter what they call it. It says the work was completed within 120 days, and then they enter executive session to discuss appointment, employment, dismissal, discipline, promotion, demotion, or compensation, investigation of charges or complaints, and that they have a new IA, which I assume stands for Internal Affairs Appointment, and there's a lot more money to be broken down in this document alone, and irregularities in where the money is allegedly going and all that nonsense. Next thing we'll look at is the Hilliard City School District Board of Education meeting from May 8th, 2023. Students were tasked with designing a shoe for kids who do not have access to shoes. And this makes a lot of sense when you realize there's a high number of Muslim named children. So children with names that are indicative of Muslim heritage. So it's understandable why such an activity would be a way to denigrate them specifically. And of course, as we know, the education departments are basically at this point open enemy operations. Then they also have a similar executive session where they talk about confidential matters. Then most of the staff at the Hilliard School District, the majority, are intervention specialists or intervention teachers, which make $47,000 to $54,000 a year. Intervention specialists and teachers did not used to be a thing. That's part of their building out for war. The Norton Board of Education regular meeting on May 13th, 2019 talked about public participation and visitors/guests were none. And that's the thing you find out a lot, is that there's usually no quote-unquote input from the public at these events. They were moved under other handbook for 2019 to 2022, high school and middle school. And one has to wonder what exactly is in those. I bet some pretty heinous things that they want to give out to students but not have known publicly. But what's interesting is that this from 2019, there were no intervention specialists, of which intervention specialists have popped up across the board this year and last year in all the school districts. These people are designed to enforce the United Nations intervention operations, enemy martial law occupation. Now, the Clark County Department of Developmental Disabilities, in continuation from the September 30th, 2023 document, they post indemnity separation between them and the Ohio Valley AV. So essentially, this is a game they play where the agreement includes indemnity of the contractor. So the contractor can get away with whatever they want, and somebody goes to the Department of Developmental Disabilities, they'll say, we can't do anything about it. And that's the game they play. Now, they paid $553.75 for an air wall enclosure sensor. And a lot of this stuff on the breakdown of this contract look particularly with the perspective towards security measures. Something a military mind would be thinking about, not a regular person. And of course, they're going to hold electronic meetings to ensure that they can't be killed. The focus of their behavioral support strategy, appearing to be anyway a clandestine operation, is to impose or make alternative ways for individuals to communicate. That sounds like what you would need a covert asset to be able to do, have alternative ways to communicate. Also, adjust physical or social environment, address sensory stimuli, adjust schedule, and establish trusting relationships. It's exactly what any sort of CIA operative would want to do to make somebody into an asset. Now, the next thing it talks about, which is really interesting, are restrictive measures, of which it lists out three types: mechanical, manual, and chemical. And if you're wondering what restrictive measures are, here it states restrictive measures are used against individuals that pose risk of harm. So yes, it's exactly what you think it is. A behavioral support strategy may include restriction of an individual's rights only when an individual's actions pose risk of harm or are very likely to result in the individual being the subject of legal sanction, such as eviction, arrest, or incarceration. There they identify to you who the primary target of their restrictive measures are, and those are those which they want to evict. They expect the people they're going to evict will fight back and stand their ground, and they want to restrict those people beforehand so they can't do it. So essentially another component of the land grab stuff, which is part of the enemy occupation operation. They also talk about, disturbingly, age-appropriate actions considered with adults but commonly used with children. So something that you would think is something bad to do with adults, they do with children, and it states it's commonly used. And then the county board or intermediate care facility will compile and analyze aggregate data extracted from DoDD restrictive measures notification application. That's pretty interesting there. So they have an application where they're going to notify it, and then the county boards and intermediate facilities will be charged with compiling and analyzing the so-called aggregate data. Now, the DoD restrictive measures, or the DoDD designation, Department of Developmental Disabilities, is relative also to the so-called Dodd-Frank Act, which is DoDD, the DoD directive, or the so-called Department of Defense directive, which is actually a publication from the universities acting under the color of the Department of Defense. And then you have the DoDD home inspection entity, DoDD camera, and the rehabilitation centers of the Department of Developmental Disabilities. These are some pretty interesting components that relate to mobilization for warfare. So when you look at these elements of warfare development and implementation that they're carrying out, the first component is the leveraging of children as hostages and spies, the employment of substance-addicted, chemically dependent, and mentally disabled individuals as soldiers, with the use of rental contracts and financial programs to incentivize and also to control them and keep them in line, and to wage war against those that pose risk of harm using the Extreme Risk Protection Orders, or ERPOs. All of these have to do with something called dictating the order of battle. These people are fully committed enemy adversaries. They're fully aware of what they're doing, and they are actively dictating the order of battle. They are structuring for war on everyone. So then when you talk about practices in security, which relate to this concept, the most people understand the conventional, which is the controlling, guarding, and protecting limited access, the restricting and hiding or concealing of redacted or stored sanitized information or objects. That's what most people understand with security. That's the conventional idea. Then you have distortional, which is usually not practiced by most people, and this involves the concept of the red herring, mix of misleading and false information, propagation of a mountain to bury relevant objects, leaving out false targets, or having exposed false targets for people to go at and hit air, essentially. This concept can be found in the swindle of the 3-card Monty or the shell game. Maneuvering-based detachments, or the maneuver-based detachments, which are all designed to misdirect, distract, to conceal, to hide through not actually restricting it, but rather propagating a whole bunch of other stuff and switching stuff around and things like that. So distortional is actually a pretty effective measure other than the conventional sense of security. Then you have triangulational, which instead of the other two focuses specifically on targeting and tailoring towards the one that you're thinking about of trying to secure against. A honeypot mechanism can assist with that, which is essentially entrapment, leaving something out there for them to bite on and then get entrapped against. It's usually focused against an individual or organization, and it deals with a specific threat to certain objects. And of course, in order to do that, you have to know your enemy. You have to know who you're trying to secure against. An example of this could be perhaps giving out fake information so that somebody can come along and falsify your identity incorrectly, right? You give out a profile that appears to be correct. It appears to be you. And then along comes the identity thief, takes all that information, and most of the information turns out to be bogus and they get in trouble. That is the idea here. Except that's specifically the honeypot, but not used in the context of some pretty woman. Now, in the overall scheme of this video, it's important to understand exactly the situation we're dealing with. And in this context, that often repeated phrase I believe is applicable, which is si vis pacem, para bellum.